I'm Linky de Jong. I used to be at UNISA. I taught family law there for 29 years. I took early retirement at the end of 2019, just before COVID, to go into full-time practice as a mediator and parenting coordinator. And I also do divorce liquidations. But subsequently, I got appointed as a research associate at the University of Limpopo. So I'm back in academia and back in research. I also serve on the Law Reform Commission's advisory committee, drafting firstly a generic mediation bill and also a family dispute resolution bill. So that's who I am currently, part-time in practice, well, full-time in practice and part-time at the University of Limpopo. Sikander? That's it.
Thank you very much. You're welcome to start your presentation. Much appreciated.
Okay. So the first slide, we get going. After divorce or relationship breakdown, most parents are able to put aside their disappointment and anger over their failed marriage or relationship and establish an effective co-parenting relationship. However, for a small percentage of parents, a high degree of conflict persists long after the separation, and these parents are unable to reach agreement about parenting issues or to shield their children from their discord. They spend vast personal resources on protracted litigation, which is a heavy drain on the time and financial resources of the courts. Where parents are in this situation, exposure to chronic conflict can have devastating consequences for their children's short and long-term adjustment and can negatively influence the children's mental, emotional, physical, and social needs. Because of the need to mitigate the damage done by chronic conflict, the process of parenting coordination has been embraced in South Africa. It is believed that the process can make a significant contribution to reducing the hostility between parents by helping them to resolve conflicts relating to day-to-day decisions and a limited number of other child-related issues. Other potential benefits of the parenting coordination process are a decrease in the number of court applications with a consequent reduction in the burden on our court system, the saving of huge amounts of time and money, and timely interventions for children impacted by co-parenting conflict. In South Africa, parenting coordination has been described as a child-centered process in which a mental health or legal professional with mediation training and experience assists high-conflict co-parents to implement parenting plans, comply with court orders, and resolve pre- and post-divorce parenting disputes without delay in a non-adversarial, court-sanctioned private forum. In terms of the process, the PC will first attempt to facilitate resolution of the parenting disputes by agreement of the parties. But if this attempt fails, the PC has the power to make directives regarding the disputes which are binding on the parties until a competent court directs otherwise or the parties jointly agree otherwise. It has been said that parenting coordination is perhaps the most significant area of interdisciplinary collaboration between the courts, mental health practitioners, attorneys, and family mediators who cooperate for the benefit of the children of parents who remain unable to co-parent effectively. Although parenting coordination has flourished over the past decade, there still seems to be uncertainty about various aspects regarding the parenting coordination process. First of all, we have the guidelines on the practice of parenting coordination in South Africa, drafted by a task team of the National Accreditation Board for Family Mediators, NABFAM, to provide guidance for PCs. In addition, The SA Law Reform Commission published a draft Family Dispute Resolution Bill of 2020, which deals with the process of parenting coordination in Chapter 7. And we also have various court decisions dealing with parenting coordination, which provide some guidance. However, when we look at some important underlying theoretical questions, it appears that the guidelines, the provisions of the bill, and our court decisions are not always aligned. The first two questions are, when or under what circumstances should the PC be appointed? And can the court appoint a PC for parents in the absence of consent by both parents? In terms of the guidelines, it appears that a PC is generally appointed for high conflict parents. The guidelines further support the notion that a PC may be appointed by the court in the absence of consent by both parties if such appointment is in the best interest of the children concerned. The guidelines also provide that parenting coordination services should be accessible to all parents, irrespective of their financial resources, and PCs are encouraged to provide their services pro bono or at reduced rates to deserving parents. In contrast, the Family Dispute Resolution Bill sets out a specific list of circumstances in which a PC can be appointed. Namely, there must be a parenting plan or court order in place with respect to parenting arrangements. A PC may only be appointed for the purpose of implementing the parenting plan or court order. A short-term, emerging and time-sensitive situation or dispute about a parenting matter must be present or anticipated. The parties must agree on the appointment of a PC, and parties must be able to afford the services of the PC. Case law has also set a number of conditions for the appointment of a PC. In PC versus SC, the father brought an application for the appointment of a PC team to assist him and his wife with decision-making in respect of their two boys pending their divorce. The mother opposed the application and particularly objected to the appointment of a team of two PCs without her consent. She argued that because the PCs would be able to make binding directives on co-parenting matters, their appointment without a consent would constitute an improper delegation of judicial authority. On behalf of the husband, it was, however, added that where it would be in the best interest of the children involved, the court, as upper guardian of all minor children, has the power to appoint a PC notwithstanding the opposition of a parent. As a point in limine, the court had to decide whether it has the power to impose the appointment of a PC on parents in the absence of consent by both parents. Acting Judge Davis ruled that the court does indeed have such power, provided that certain conditions are met, namely, the welfare of the children involved must be at risk due to high levels of parental conflict. Mediation must have been attempted unsuccessfully. The person appointed as PC must be suitably qualified and experienced. And the fees charged by the PC must be fair and reasonable. The judge concluded by saying that where there's a court-ordered parenting plan in place and there's evidence which shows that the child is at risk due to a demonstrated inability or unwillingness of the parents to co-parent amicably in the best interest of the child, then the circumstances are sufficient to warrant the appointment of a PC. Furthermore, in other cases, an interim court order to the effect that one parent's contact needs to be phased in, as opposed to a court-ordered parenting plan, was sufficient grounds for the appointment of a PC. In S versus S, the father brought an urgent application, pending a Rule 43 application, for primary residency of the party's 3-year-old daughter, as the mother was a high-class prostitute and a cocaine addict. The court appointed a PC, and in that specific case, Lynette, who's going to address you next, she was appointed as the PC with as wide a discretion as possible to phase in the mother's contact with the girl up to the point where the parties would have equal residency. So, what are the conditions precedent for the appointment of a PC? Although high conflict isn't mentioned as a prerequisite for the appointment of a PC in the Family Dispute Resolution Bill, it's clear from the guidelines and our case law that parenting coordination should be reserved for high conflict co-parents. As parenting coordination is the most intensive intervention available to assist parents to co-parent more functionally, other less intensive options, such as parent education programs and mediation, should be considered before a PC is appointed. It further appears that some of the prerequisites for the appointment of a PC, as set by the Family Dispute Resolution Bill and case law, are out of touch with reality, too strict, or unnecessary. In the first place, it appears that the existence or anticipation of a short-term emerging and time-sensitive situation or dispute about a parenting matter, as is required for the appointment of a PC in the bill, might be too restrictive a requirement. It appears from S versus S that the appointment of a PC is particularly useful in circumstances where there's no emerging and time-sensitive situation, but where there's an expectation that a parent's involvement will increase once issues that are restricting his or her parenting involvement have been addressed. This might also be the case where a co-parent's parenting involvement has been temporarily restricted for reasons related to the child's development, such as where a child is still very young or has special needs that have restricted the co-parent's involvement. Furthermore, the bill's prerequisite of informed consent by both parties to the appointment of a PC seems to be out of touch with practice. In TC versus SC, the court expressly stated that the court does have the power to impose the appointment of a PC on parents in the absence of consent by both parents. This sentiment is also shared by the guidelines. If consent of the parties were to be a requirement for the appointment of a PC, many high conflict parties who have great difficulty in reaching agreement about many issues, let alone a process that would cost them time, energy, and money, would be denied the benefit of the parenting coordination process. Lastly, the condition that mediation should have been attempted unsuccessfully before a PC may be appointed seems to be superfluous, as mediation is part of the parenting coordination process. A PC would always first attempt to facilitate the solution of the parenting dispute by agreement of the parties, and only if they were unable to resolve the matter in the mediation phase would the PC resort to making a directive on the dispute. It is therefore proposed that the conditions precedent for the parenting coordination process should be the following: the presence of intractable co-parenting conflict, the existence of a parenting plan or a court order with respect to parenting arrangements or contact with the child, an indication that the appointment of a PC is in the best interest of the children involved, and an indication that the process is affordable. Let's look at the next two questions, namely, which issues could be dealt with by a PC, and can a PC oversee both the development and the implementation of a parenting plan? from providing that a PC may only be appointed for the purpose of implementing a parenting plan or court order, the Family Dispute Resolution Bill provides that the appointment of a PC may not divest the court of its exclusive jurisdiction to determine the fundamental issues of guardianship, care, contact, and maintenance. To give practitioners more clarity on what this entails, the bill provides that a PC will only be able to make directives in respect of a child's daily routine, a child's education and extramural activities, the temporary care of a child by a person other than the child's parents, the provision of routine medical, dental, or other health care to a child, the discipline of a child, the transport and exchange of a child, contact with a child during holidays and special occasions, and other matters agreed upon. However, a PC may not make directives in respect of a change to the guardianship of a child, a change to the allocation of parental responsibilities and rights, a substantial change to contact with a child, the relocation of a child, the need for supervised contact by either parent, or the need for psychological or psychiatric treatment for either parent. The guidelines contain a more exhaustive list of issues that may be dealt with by a PC. Over and above the issues set out in the bill, the list includes child rearing issues, religious observance and education, communication between the parents and the children, alteration of the appearance of the children, including haircuts, tattoos, and body piercings, psychological testing or other forms of assessment of the children and parents, substance abuse testing for either or both parents or a child, and parenting education for either or both parents. Case law has also dealt with the specific issues that PC is or isn't permitted to deal with. Besides the conditions for the appointment of a PC, Acting Judge Davis in PC versus SE stipulated certain limitations that need to be imposed on the functions and powers of the PC, even in circumstances where the parties agree on the appointment of a PC. The first limitation is that the PC should be appointed after the parents have reached agreement on the contents of their parenting plan, whether interim or final, and the parenting plan has been made an order of court, so that the PC's role would be limited to the implementation of an agreed upon parenting plan and/or compliance with an existing court order. Another limitation concerns confining the decision-making power of the PC to ancillary rulings which are necessary to implement the court order, but which don't alter the substance thereof. The judge concluded that the PC's decision-making powers should always be confined to minor day-to-day conflicts which doesn't trespass on the exclusive jurisdiction of the court to determine and amend parental responsibilities and rights. In direct contrast to TC versus SE, there were, however, cases in which PCs were appointed to create parenting plans. In CM versus NG, the Cape Town High Court ordered that a facilitator, as a PC was known at the time in the Cape, be appointed after the separation of same-sex partners to assist them with joint decision-making as well as the drafting of a parenting plan in respect of a child conceived by artificial insemination during the relationship. Similarly, in Centre for Child Law versus NN and NS, the Pretoria High Court appointed a PC, once again Lynette, to assist two sets of parents whose babies had been swapped at birth. Oh dear, Can you still see me? It says internet unstable, but I hope you can still hear and see. So in this case, the PC was appointed to assist the two sets of parents whose babies had been swapped at birth to develop an appropriate parenting plan and resolve any possible conflicts that might arise in circumstances where the court ordered that the children should remain in the care of their biological parents. A last case that concerns the issues that may be dealt with by a PC is Van der Merwe versus Briver and Van der Merwe. In this case, the mother of 3 children brought an application to have a facilitator's directive reviewed and set aside by the court. The directive purported to vary a maintenance order of the High Court by reducing the maintenance amount that the father had to pay to the mother when the oldest child left for university and the middle child for boarding school. The mother claimed that the facilitator had exceeded the powers as facilitator. In terms of a parenting plan, which was incorporated in the order upon divorce, the facilitator was authorized inter alia to regulate, facilitate, and review issues relating to the children's maintenance and to issue binding directives. The court found that the words regulate, facilitate, and review issues relating to the children's maintenance were indeed wide enough to afford the facilitator the power to vary the original maintenance order, and that she had therefore not exceeded her powers as set out in the order upon divorce. However, acting Judge Vos found that the initial order upon divorce constituted an impermissible delegation of judicial authority by allowing the facilitator to determine the maintenance of the children, an aspect of parental responsibilities and rights, which only the parents may determine in terms of Section 33 of the Children's Act, and which they may not, in terms of Section 33 of the Act, delegate to a third party. The court further pointed out that in terms of Section 165 of the Constitution, the judicial authority of the Republic is vested in the courts, and that in terms of Section 2 of the Constitution, conduct which is inconsistent with the Constitution is invalid. The court therefore concluded that insofar as the initial order upon divorce purported to delegate judicial authority to the facilitator, it was invalid and unenforceable, and the facilitator's directive was set aside. From the Family Dispute Resolution Bill and case law, particularly Van der Merwe versus Briver and Van der Merwe, it appears that the PC should never be allowed to make determinations about or any modifications to parental responsibilities and rights, namely care, contact, guardianship, and child maintenance. Where a court order purports to give a PC such judicial authority to engage directive that a PC may issue would be invalid. Therefore, whenever issues such as care, contact, and child maintenance are referred to PCs for determination or substantial amendment, they should refer the matter back to the court to first resolve these issues or simply decline the appointment as PC. However, where a PC's directive doesn't concern parental responsibilities and rights, but matters incidental to such responsibilities and rights, such as the matters listed in the bill and the guidelines, such directive wouldn't constitute an improper delegation of judicial authority and would be valid and enforceable. As parenting plans determine parents' parental responsibilities and rights, issues on which a PC can't make directives, it follows that a PC should never be requested to develop a parenting plan. As Section 33.2, read with Section 33.5 of the Children's Act correctly indicates, parents who can't agree on how to exercise their parental responsibilities and rights should seek the services of a mediator to assist them in agreeing on a parenting plan, not a PC. Despite some South African court cases allowing PCs to develop parenting plans for co-parents, the express provisions of the Family Dispute Resolution Bill, the purport of the guidelines, and findings in other cases make it clear that PCs should only be appointed for the purpose of implementing parenting plans or court orders in terms of which parents' respective parental responsibilities and rights have already been determined. Interestingly, in North America, the latest guidelines for parenting coordination of the Association of Family and Conciliation Courts do anticipate that there may be circumstances where a PC is expected to create a parenting plan or parts thereof, such as where the parents have an interim or temporary parenting plan, while processes such as care evaluations are occurring, and the PC is tasked with establishing a more permanent parenting plan, or where the parents arrive at the doorstep of a PC with an inadequate and insufficiently detailed parenting plan. Even so, in South Africa, the position is clear. Only the parents by agreement or the court may determine or amend their respective parental responsibilities and rights, and no third party has the right to do so. And the next question, who should be appointed as a PC? Because parenting coordination is one of the most challenging and complex family dispute resolution processes, and further, because the delegation of decision-making authority is a serious issue, extremely high standards are set for PCs in both the guidelines and the Family Dispute Resolution Bill. In terms of the guidelines, a person seeking to serve as a PC must at the minimum have a mental health or legal professional qualification, be a NAPFAM accredited family mediator, have specific training in the parenting coordination process, have 7 years professional experience in family dispute resolution, and be a member of a designated professional organization such as the LPC or the HPCSA, or have served for a period of 7 years on the bench as a judge or magistrate. In terms of the bill, a PC must be a licensed mental health professional or a licensed legal practitioner practicing in a sphere associated with families. Have training and experience in family mediation and be a certified family mediator in terms of the generic Mediation Act, which is currently being drafted by the Law Reform Commission, and have training and experience in family arbitration. Some of these standards are, however, open to criticism. It appears that specialized experience and training in both the legal and the psychological domains are a requirement for minimum competency. A specific parenting coordination training program, as envisaged by the guidelines, should therefore entail comprehensive training which covers both the legal and the psychological domains. It's doubtful whether experience in family arbitration, as envisaged by the bill, would address the multidisciplinary perspective of the parenting coordination process. At present, the available family arbitration training program offered by FLAPSA, the Family Law Arbitration Forum of South Africa, is exclusively offered to legal practitioners, and the requirement that PCs are to have training and experience in family arbitration would exclude all mental health practitioners as PCs. In practice, parenting coordination is currently undertaken by practitioners belonging to multiple disciplines, including psychologists, social workers, family mediators, and legal practitioners. The current diversity of professionals involved in parenting coordination is essential, since there's such diversity in the nature and background of the high conflict parents who are in need of the process. Legal practitioners and judges should therefore carefully consider the circumstances of each case before a specific PC is appointed to ensure that the background and character of the PC fit the relevant circumstances in which the high conflict co-parents and the children find themselves. Okay, another question. What approach should be followed in the parenting coordination process? The guidelines, the bill, and the standard parenting coordination clause in settlement agreements or parenting plans stipulate that the functions of a PC are, that they stipulate what the functions of a PC are and what it is that a PC should do. However, they don't indicate how PCs should exercise their functions or contain any pointers on the approach to be followed in the process. In North America, the following two approaches are generally utilized, namely, the creation of a parallel disengaged model of co-parenting, where engagement between the parents is minimized and the PC acts as a functional link between them in respect to their parenting, and the child-centered team-building approach, which focuses on co-parental solidarity. Co-parental solidarity, where all involved adults are managed to create a functional partnership, seems to be a very important catalyst for children's healthy emotional growth. PCs in South Africa should take note of these approaches and collaborate on the development of a unified theoretical model to inform the practice of parenting coordination. Should children be included in the parenting coordination process? In terms of various provisions of the guidelines and the bill, PCs are obliged to facilitate child participation in all disputes concerning the child in accordance with sections 10 and section 31(1)(a) of the Children's Act. Despite these peremptory provisions, it appears from research undertaken in South Africa that children are often not consulted in the parenting coordination process, whether directly or indirectly through a child specialist. Obtaining the child's voice directly is indeed the most reliable way to bring the child's needs and preferences to the parenting coordination process. However, understanding the perimeters of developmental psychology and being able to engage with children in such a way as to obtain their true voices, unencumbered by parental alienation or fear, is a skill that requires extensive training and relevant experience. Child specialists should therefore be called upon to determine the voice of the child if PC's training and experience aren't adequate to enable them to interview children. After obtaining the child's views and preferences, either directly or indirectly through a child specialist, such views and preferences should be made available to the parents so that they can inform any agreements that are negotiated in the process. If no agreement can be reached, the PC is then able to make a directive on the dispute, and the information gleaned from the child helps the PC to make a decision that's in the best interest of the child. Does a PC need to afford the parties a formal hearing before he or she makes a directive? In Van der Merwe versus Privaat and Van der Merwe, where the PC's directive was set aside because it purported to amend a child maintenance order of the High Court, The court required a fair hearing by the PC in the process. It seems that the judge's view is that for each directive that a PC makes, there should have been a statement by each party, discovery of relevant documents and information, and a chance to cross-examine the other party's statement. Despite this decision, it's evident from the guidelines and accepted in practice that PCs are under no obligation to afford the parties a formal hearing. PCs are, however, required to provide the parties with a fair process. Both parties must be heard and given the opportunity to question each other's arguments. In this regard, the bill prescribes that the parties need to state their case in the presence of the other party. But this provision isn't supported. Where the parenting coordination process has created a parallel, disengaged model of co-parenting, it would be counterproductive to let each party state his or her case in the presence of the other party. As PCs generally interact with clients via email and not in joint face-to-face meetings as in mediation, there's no reason why each party can't state his or her case in an email on which the other party is copied. Each party should then be given an opportunity to answer and make comments on the other party's case, also by email, upon which the PC could make a directive. But thanks to COVID-19, online PC sessions are now also an option and provide an opportunity for parties to be both in their own private and familiar space and at the same time in the same virtual space where a hearing, not a formal hearing, but an informal hearing can take place. Is parenting coordination really a non-confidential process? The bill states that no communication between the parties and the PC may be confidential. As PCs hail mainly from other professions such as mental health, law, and mediation, where information and disclosures are strictly confidential, PCs and parties find it difficult to understand the exact extent to which information and privacy are protected in the parenting coordination process. In terms of the guidelines, it appears that confidentiality doesn't apply to internal communications in the parenting coordination process, namely communications between the PC and the parents or others involved in the process. However, confidentiality does apply to external communications, namely communications between a PC and other audiences beyond the parenting coordination process. Liminal communications, which pertain to communications with other professionals and non-professional support, who are often integral to the parenting coordination process, but who occupy a somewhat ambiguous threshold position, appear to be a gray area where the confidentiality of communications would depend on the PC's discretion as to whether otherwise privileged mental health or other sensitive information about parents should or shouldn't be regarded as part of the parenting coordination process. In the light of the broad definition of personal information in POPIA, which inter alia includes information relating to mental health and belief, information about a person's medical or financial history, a person's opinions and preferences, private correspondence, and opinions about a person, this is something that should be clarified as soon as possible to prevent potential claims and charges against PCs for unlawful processing of data under POPIA. The last question: what's a PC's relationship with the court and the party's legal representatives? only the guidelines contain provisions on PC's relationship with the court and the party's legal representatives. In the first place, the guidelines provide that PCs may be requested by the court to provide a written or oral report to the court. The guidelines further require that court orders must clearly define a PC's scope of authority and responsibilities. Further, PCs are to follow the court's directions regarding provision of a copy to the court of any directives, report, or recommendations made by them. In addition, the guidelines provide that PCs must communicate with all parties, children, legal representatives, and the court in a manner which preserves the integrity of the parenting coordination process and considers the safety of all participants. Courts must therefore be careful not to request PCs to act in roles that exceed their scope of authority. Judges further need to be trained to realize and appreciate the value that PCs can provide in difficult cases. Although the parenting coordination process is designed to operate outside the court, it's important that there should be contact between a PC and the judge who's responsible for the PC's appointment, especially in circumstances where a case management judge has been appointed to a case, or where a PC is having a difficult time with one or both parties. To give the parenting coordination process the gravity it deserves, it's further advisable that all directives made by PCs should be filed on court files for cognizance by the judges dealing with these cases. In this regard, the bill provides that if PC's directives are filed with the court, they would be enforceable as if they were an order of the court. There should also be regular contact and an exchange of information between PCs and the parties' attorneys from the outset of the parenting coordination process. If possible, new facts or forthcoming directives should be discussed with the parties' attorneys to enhance trust and respect between PCs and the legal profession, and to enable attorneys to prepare their clients for changes that might otherwise give rise to extreme behavior. When necessary, attorneys can also be invited to attend joint parenting coordination sessions with parents to level the playing field where one parent is dominating such sessions. And now it's over to Lynette for some practical comments on the 10 questions which I've just discussed with you. Okay, Lynette.
Thanks, Linky. And yeah, just thank you for putting together a really, I think, good and helpful presentation on all the case law and also where we are in terms of the Law Reform Commission and the new, hopefully the new act that will come in quickly, I hope, because we desperately need it. But yeah, so I'm not going to deal with legal stuff. That's not my domain, and it's not my area of expertise. I'm a clinical psychologist. I've been in practice for over 30 years, and for my sins, I think there must be many of them, I have landed up being appointed as a parenting coordinator in many cases. It's very challenging. But I have to say it's also very rewarding when you can see things starting to work well and the children's lives are really running a lot more smoothly. It is very rewarding. So that's just by way of introduction. Okay, so yeah, so I'm going to talk very much on a level in terms of just practically speaking, acting as a parenting coordinator, what our experiences are, but also what our needs are, and where I think there need to be adjustments made. Anyway, so under what circumstances should a parenting coordinator be appointed? I agree 100% both with, with what Linky has been saying, but also in terms of just what's in the guidelines that have been drafted and what's in the draft bill is that the parenting coordinator really needs to be appointed by a court order, or it can be by mutual agreement. I want to say on a practical level, quite honestly, that to be appointed as a PC by mutual agreement, in my opinion, is pretty much a waste of time. And I say that with, maybe it's just, maybe there are other people that are PCs that are better than me that can get people to work with them when they are appointed by mutual agreement. But my experience is that when you're appointed by mutual agreement as a PC, as soon as one of the parents doesn't like a directive that you issue, and it happens, I mean, it happens all the time, but when you're not appointed by a court order, the one that doesn't like the directive just says, well, I'm just not going to comply. And it leaves the other parent really with nowhere to go. And yeah, they can't affect the directive and its implementation. Whereas if the PC is appointed by court order, the parents do take it more seriously. And invariably in those court orders, it says that the PC is empowered to issue directives which will be considered to be binding on the parents until or unless a court of competent jurisdiction overturns that directive. And I agree with that clause in court orders, quite frankly. I fully respect that the court has every right to review any directive that a parenting coordinator issues. That is right. There should always be a review process, and we'll talk about that a bit later. But in essence, I do think that when the parenting coordinator is appointed by court order, the parents take it more seriously, and even if they don't like the directive, they will comply with it or engage in a formal review process, which I'll talk about. But I think that, yeah, so I can't say never, but I am extremely loath and very rarely will I accept an appointment as a PC if it's not by court order, if it's done by mutual agreement, because I just know it wastes the parents' time and money, quite frankly. But yeah, when and under what circumstances, so that they should, and as Linky's already gone through it, and I'm not going to actually go through that all in detail now, but I think especially in the high conflict families where there's personality disorders or psychiatric disorders, you need a hands-on person to manage those ups and downs. It's challenging. Where there's a long history of litigation, I've had a case where in this child's first 5 years of his life, his parents had been in court 9 times, and I was appointed as the PC. I wasn't the first, I was the third. The first one resigned within a month. The second one was Judge Kathy Satchwell. She resigned after, I think, about 8 months. And she actually said that case put her off family law, which I'm very sad about. Anyway, I then lasted just over a year. Then another advocate was appointed and she lasted 3 months. They don't have a case manager now because nobody, I mean, a parenting coordinator, because nobody will take it on. But so long history of litigation, yes. Where there's an imbalance of power, history of domestic violence, where there's parental alienation, all of those sorts of things, I think really, really require a parenting coordinator. But very importantly, when contact needs to be phased in, and I just want to quickly highlight that, because parenting is a fluid process, even in the best of circumstances. So even in your very traditional family where mum and dad are together, children all living, with mum and dad, parenting still has its ups and downs, and it's fluid, and it's challenging, and it's difficult. So in your high conflict families, even more so. And then when parenting has to be phased, the contact has to be phased in because one of the children is very young, or the children are young, it's really, really necessary that you have somebody hands-on who can make those minor adjustments. I'm not talking about major ones, but minor adjustments in the best interests of the children, because children go through different developmental phases. They are not textbooks. And you can't, when a child is 18 months old predict exactly how that contact schedule should be going when that child is 3 years old, 4 years old, 5 years old, 8 years old. So there you really need a PC. Where there's also a history of addiction, a PC is really necessary because unfortunately addiction is a battle for people and there are relapses, and you need somebody who's on hand, on speed dial, who can actually intervene in the best interest of the child, but also just kind of in a level-headed way. But I do want to highlight that parenting coordination is not for all families. So the next point, can the court appoint a PC for parents? Sorry, Linky, if you can just change the slide, please. Point of the PC for parents in the absence of consent of both parents. And I think Linky's gone through that very comprehensively, and I think we've got legal precedent there, and I think it'll also be dealt with in legislation going forward. But from a very practical point of view, my experiences, and I say that at the bottom of my slide, yes, please, the court should be allowed to do that and able to do that, because you have the situation where if one parent is not going to agree, if you've got a massive imbalance of power, for example, and I hate to use this example because it's such a popular one at the moment and way overused, if one parent has narcissistic tendencies, so they want to be in control, they are not going to like the idea of having a PC appointed over them, and they're going to resist it unless they believe that they can convince the PC to be always on their side, but that's another story. So they're going to resist it. And then what happens? Then it means the other parent is left really with no avenue. And they're going to land up forever going back to court. So, which is costly and difficult and emotionally draining. So I do believe that from a practical point of view as a PC, that they should actually, the court should be allowed to actually appoint PCs, even if one of the parents, or I suppose even both of the parents, if they don't consent to it. If it's in the best interest of the child, surely that takes precedence. And I do think that part of my experience has been is that I think that part of that is that if the parents are warned early on by their legal representatives that the court may actually appoint a PC without their consent, and that it's in their own best interest to be part of that process, so that they can at least look at who, kind of the various options, should we call it, that they've got in terms of who could be appointed, so they have some say in that. I think that's far preferable. Surely I would rather people, if I'm appointed, that they would have had a say in it, than just having me completely kind of imposed upon them. I don't think that's a good start, but yeah, if it is what it is, it is what it is. Okay, so the next point, what issues can be dealt with by the PC? And Linky has gone through that very clearly. But I think what I just want to say here is that the court order should define the powers of the parenting coordinator. It is incredibly important that that court order is written correctly. I'm the PC in many cases, and some of the court orders that I see and that I receive are really, really concerning, that the powers that I'm given are far too broad, I have to say, and it creates problems. If that court order and the powers of the PC are not properly drafted, it creates massive problems for the families, for the mum and the dad and the children, and also the PC, because the parents then, for example, expect the PC to deal with something. So, for example, maintenance. They will expect the PC to deal with maintenance because the court order is that broad that the PC kind of can. And personally, I'm not happy to deal with maintenance. It's not my area of expertise. I am trained in maintenance mediation, but I still don't believe that I'm the best person to do it. And anyway, I don't think it's right that I should be doing it as a PC. But the parents look to the PC and say, but, the court order doesn't restrict you in that sense, or it gives you the power to deal with absolutely anything. Please deal with it. And so it just adds difficulty to the whole PC process. And so I really, those powers need to be very, very clearly defined in the court order. Linky's gone through a lot of what can be covered in there. So, you know, and as I said earlier, parenting is a fluid process, and it's unique to every family. It really is. I've yet to come across any 2 PC cases that are the same. So the court order needs to define those powers, but it also needs to leave space open for specific little nuances to do with that family. For example, one of the examples I give there is like electronic contact. That's something that's sorely ignored, actually, I think, or not dealt with in court orders and in terms of what the PC can deal with. And it's a very relevant aspect in today's world. Children really, children need to be protected, I think, a lot of the time from too much internet access. We know that it's not good for them, not just in terms of a safety point of view, in terms of all those people on this internet that are looking for children to harm, but also just in terms of sexting and the way children send inappropriate photographs of themselves to each other, and it happens a lot. And those photographs are there forever. Once they're out there, you can never get rid of them. And children, you know, and parents will have very different views on that. So, for example, I've got a family where the dad feels that pornography is really okay. It's legal in this country, and he views pornography, and he doesn't feel that that's of any problem. But he has said that as a young boy himself, he used to view pornography. He doesn't believe it's damaged him in any way, and so therefore he believes it's quite okay for his 14-year-old son to be viewing pornography. Mom, on the other hand, is very opposed to it, so it's that sort of thing. So that's just an example of children and electronic contact. The other thing too is just in terms of how long children should be allowed to be exposed or have screen time, you know, and parents can have vastly different views on that. So definitely that type of thing. And so the court order needs to be very well constructed. And my advice always, or my request always, is that when these court orders are being drafted, if I am going to be appointed as the parenting coordinator, or even if it's not me and it's somebody else, that it's wise for the attorneys to get advice from experienced PCs as to what should be in that court order. Okay, so next one. I'm watching the time and I'm hoping I get through this all. Okay, can a PC oversee the development and implementation of a parenting plan? Linky has covered that, I think, very, very well. In terms of from the health professional's point of view, if you're going to mediate and you are going to be a PC, that's a dual relationship, and the HPCSA prohibits us from doing that for good reason. And I think that and I've got lots of orders that actually I'm appointed as the PC and I have to develop the parenting plan, and I won't. Because just on a very practical level, how do you expect a mum and a dad to sit with you and to be mediating the contents of a parenting plan, and then when they don't agree on something, that you now issue a directive on that, because you've got to also, because it's usually you're implementing, for example, contact while you're in this process of mediation. It is an absolute mess. And I don't think it's fair on the parents to expect them to then happily in the next mediation session be sitting there and feel that you are being impartial and that you're hearing them because you're now mediating another aspect of the parenting plan, when you've just a week before issued a directive that doesn't accord with what they feel the contact should be, for example, or what's, kind of the schooling or something like that of the child. So you can't put people in that position. It's not fair on them. And so, yeah, I don't believe that you can do that. I do think that the parenting plan, however, should be drafted in a manner that allows the PC to deal with issues that arise and to make changes made by agreement or by a directive. And so that clause needs to be very, very clear in the parenting plan that's mediated by the mediator. Okay, so next point, who should be appointed as a PC? I just want to say parenting coordination is very taxing and time consuming. And it, as Linky has gone through already, it really requires experienced mediation skills, a broad knowledge of legal and psychological aspects. They do need to be accredited mediators, and they do need to be either attorneys, advocates, or judges, or psychologists and social workers. You need to have that, and the training of PCs that Linky has gone through needs to be very specific training. Excuse me, I'm just going to drink some water. But what I want to highlight here is the benefit of a parenting coordination team. And forgive me, Linky and Johan, because I know you also know, and Charlene, this is something that I often talk about, and I'm very pro, let's say, is a parenting coordination team. And that is where you have two people appointed for your parenting coordination, not one. And you ideally have one person from the mental health professions, so either a psychologist or social worker, and one from the legal profession, either attorney, advocate, judge, magistrate, somebody like that. Okay. Now, I know that the big argument, because it's always said, is cost. Okay, so now you're paying double costs. No, that's not the case. The one party, whatever the issue is that is raised, whether it's it has more of a legal aspect to it, or whether it has more of a parenting, psychological, whatever aspect to it, the relevant PC of the team deals with that issue, or they will collaborate. They will quickly, talk about it between themselves, and then the one of them will deal with it. It is incredibly beneficial to have a parenting coordination team. You get the best of both worlds for the price of one, because whichever one deals with it bills for their services. So you don't get a doubling up of costs here, but you do get a really, really good service. And so I'm very, very keen on parenting coordination teams. I was appointed as part of a parenting coordination team with Johan Fente. Johan is also an accredited parenting coordinator. And I think it worked really well. I'm not saying that the outcomes of what happened in that case, and it's still ongoing, have always gone well. We can't control the adults in the case, unfortunately. But working as a team has been really, really powerful. And it's very comforting as a parenting coordinator when you've got a colleague on hand that you can kind of fall back on. So I really, really, really ask that you all seriously consider that type of approach as well. Okay, next point, number 6. Okay, what approach should be followed in the parenting coordination process? So Linky covered it from a legal point of view, but also different approaches that are used overseas. And so I want to look at that question slightly differently in terms of just on a very practical level. So parenting coordination, the process you follow, whether you are seeing the parents together or separately, and that will be determined by the parent's psychological capacity, whether they can sit in a room together and work productively, or whether it becomes just too acrimonious and aggressive. As the PC, you don't want to be adding to the conflict. You actually are here to try and lessen the conflict so that the parenting can run more smoothly and they can work better together. So my experience is that usually separate consultation, so you've got a parallel process happening, works better. I have got some where I will see them together. The one is, and I often use this example, where the mom is an advocate and the dad is an attorney. So those joint sessions are very heated, but they have a level of understanding of this type of process, I think, that probably most of the public don't. And so they will have their argument. I will then literally pull them to order and and then stop it, and then I'll issue a directive. And they do abide by it, which is also helpful. But anyway, so normally though, it is separate parallel consultations. I work PC in terms of on an as and when needed basis. Okay, so I am not asking that parents keep coming and consulting with me if things are running smoothly. If all is going well, I'm not going to intervene. I personally have absolutely no need to, and they don't need to. You don't need to be messing with something that's working well. So it's only when there's an issue that comes up that they cannot resolve. And I make that very clear in the beginning as to how that process works and how it's their responsibility. These are their children. It's their parenting process. I'm here to help them. So if they have an issue, they need to contact me, and then I will set the process in place, where I will then consult with each of them individually or whatever, get their views. And then I try and follow a process very much like the way the courts work. So the parents each get to say what they want to say. I will then have another consultation, or we might do some of that over email. By the way, I do a fair amount over email because it's just user-friendly for everybody and cost-efficient. I then go back to them and say, okay, but Dad, Mom said this, and this, and Dad, Mom, Dad said this, and this. So I get them, to kind of, they have their own opportunity to clarify, or a rebuttal opportunity, or whatever it is. I think that's important. I really do. They surely have a right to do that. That process may carry on for a little longer than normally what would happen in the court process, but to giving them a chance. But there comes a point where if you cannot get them to agree through mediation, then you have to actually issue a directive. And I will actually then say, okay, I've heard what both of you had to say. I'm not hearing any new information from you on this. You don't appear to be moving closer towards an agreement, and therefore I'm going to issue a directive. So they know that it's going to come. And then I will issue a directive. I do, those are always reduced to writing, those directives. And in that document, I will actually very succinctly set out what each of the parents' views were on it. If I have a particular piece of information that needs to be considered, for example, it might be the contact for an 18-month-old child. And as a psychologist, I know what I know, and I know what's found to be good or what's damaging for children. So I may put that in. I might say this needs to be considered or whatever. Or it might be about what school the child's going to. And I might put in there that, it needs to be remembered that this child has challenges or barriers to learning. And the school that one of the parents is considering is very pressured academically. And the school itself has indicated they don't believe the child will be able to flourish in that environment. So I might put that type of information in, and then I issue the directive I set it out like that for the simple reason that anybody else reading that would know what each parent's views were, succinctly, admittedly only, but also just get a good overview of this and how come therefore the directive was reached. Okay, I do from the get-go point out to parents that they can, and they fully have the right to, and I support this, to ask for a directive to be reviewed. That we've got to have that. And as PCs, I think that should be part of the standard process that PCs actually will follow. That once they've issued a directive, if a parent wishes for it to be reviewed, that the parent should then approach the PC and say, look, I feel very strongly about this. I want this reviewed. That the parent then can then explain to the PC what they think is the new information, or the information that they believe was not considered or they failed to raise, so that the PC can then have that information. The PC can then say, okay, hearing that, I think, you have a good point, or whatever it is, or yes, this does need to now be considered. And the PC can review their own directive, as a court can review its own court order. But at that point, if the PC feels no, there is no new information or nothing warrants a review of that directive, the parent also needs to know and should be informed that they still have the right to then go to the court to have the PC's directive reviewed in the court. And that is also good. I think that process should always be there. And the court is the upper guardian. The High Court is the upper guardian of all children and should have that power. And I fully support that. So that's on a very practical level, the process and thinking behind that. So, and I'm going to try and go now at double speed. Okay, next slide. Number 7. Should children be included in the parenting coordination process? Linky's gone through that. Yes, I agree they should, where appropriate. You don't want to overexpose children to professionals all the time. That becomes very, very challenging and draining and scary for children. It's hard for parents as adults, so even more so for children. So yes, they should be, but where appropriate. There are many aspects that PCs deal with it. I'm not sure if it's really necessary that the children's opinions are obtained on those aspects. And I'm saying that as a psychologist who's very pro-parent child participation. So I'm very keen to bring children in wherever possible and relevant, but it's not a blanket yes for everything. Definitely not. And also, the person who gets the child's views needs to know what they're doing. It scares me when I hear about how sometimes children's opinions are obtained and how their participation is included in these processes. And I strongly feel that it should be a social worker or a psychologist. And it can be the PC sometimes if they're trained in that. But I want to say too that sometimes it shouldn't be, depending on what the aspect is that's under discussion, because it's sometimes good to have a completely independent person get the child's views and feed that back into the process. That can be done verbally in a joint session. But yeah, so I'm very supportive of that under the right circumstances. The next point is, does a PC need to afford the parties a formal hearing? I think that's always preferable. You obviously always want to hear both parents' points of view. But there are times, and I've had this, where a parent just refuses to engage with me on that aspect. No, they're not going to. They come up with all sorts of excuses. No, they don't have time to come. It might be something like what school the child is going to go to next year. So this is something that comes up a lot at this time of the year, and it's already very late at this time of the year. The parents can't decide. And the one parent is absolutely adamant that my child will go to that school. For example, my son will go to that school because that school has an excellent record in producing Springbok rugby players. Okay. And his son hates rugby, doesn't want to play rugby, is scared of rugby, and actually is hugely talented in music, for example. And dad just will not tolerate this. He's not going to have, and I'm sorry, I'm going to say this, I don't mean this disrespectfully of anybody, but this is something that I often hear as a PC. Dad's not going to have his son be a morphine. So he's going to make him go to that school and play rugby. And the child just, it's not his passion. But he will not engage with the PC on that because he doesn't want, he thinks that by doing that, the PC then won't or can't issue a directive on that. But it's desperate now because this child needs a high school to go to. And time has kind of lapsed already. And this child still doesn't know what school he's going to. So all his peers are now like, oh, I'm going to this school and that school and where and what. And he's like, I don't know what school I'm going to because my parents can't decide. And it's wrong. And parents get very clever, and they do. They dilatory on these things because they don't want to not have their way. And I think as the PC, you should actually at some point be able to draw a line. And I have done that, and I've asked that parent, please to engage with me, please to tell me, please to give me their opinions, even if it's just an email form, etc., etc. And they just won't give an opinion. And then I will eventually say, look, if you can't give me your opinion by such and such a date, you leave me with no option but to issue a directive. without your full input, which I don't want to do. I would rather have your input, but we have to actually bring resolution to this issue. As a PC, if you can't do that, what are you doing? Why are you there? You're not helping. So, and so, yes, it has to be in the child's best interest. There has to be good reason to do that, but I think there's a place for that. Okay, next one. Is parenting coordination really a non-confidential process? Linky has gone through all of that, and I'm not going to go through all of that, but basically to say it's very important that parents understand the non-confidentiality of the process within the parenting coordination process, so that anything they tell you, you can discuss with the other parent, but that outside of the PC process, it should remain confidential. So it's a very interesting kind of dynamic, the whole confidentiality, non-confidentiality process within PC. I will say, though, that even with that, so within the process, it's not confidential, but I think PCs need to be wise and need to really think carefully about what information they feed backwards and forwards between the two parents. People will often say things in the heat of the moment that they actually don't ultimately mean in its fullness, let's say. And PCs need to actually just be quite careful that when they feed back information or want to get the other parent's point of view on something that's been said, that they do it in a manner that doesn't build the acrimony between the parents, that they do it in a way that hopefully models for the parents a way of actually being able to debate something, but in a far more constructive way. So I think that takes a lot of skill. And then, yes, please remember about the Puppy Act. And then also the other thing too is you've got to keep in mind if there are protection orders regarding forms of communication. I have got some families where the mum and dad are only allowed to communicate over email. And they're not allowed to communicate over text messages, which is unfortunate, because ideally I like to set up WhatsApp groups with each family for the parenting coordination, so that on the WhatsApp group they can discuss things. But I'm thinking of one case in particular, the court order, the protection order that the mum has against the dad because of past history in the case, that he is not allowed to actually communicate with her over text messaging. So yeah. And then the last one, what's a PC's relationship with the court and the parents and the parties' legal representatives? And Linky has gone through that as well. I'm not going to talk much on that either, but just to say that the PC must be guided by the court, answers to the court, comes under the court, stands for the court, however you want to look at it. But basically the court is above the PC and should be that way. That I think that the whole idea of having PCs is to try and minimize running back to court the whole time and engaging kind of the attorneys being engaged the whole time and kind of fighting for their client. Attorneys can be helpful sometimes in using them in the PC process. I hope you can all hear me. I see my internet's a bit unstable at the moment, but thank you. But they can be helpful, and sometimes they can actually help to calm things down a little bit. But on the whole, I think I try to actually keep the whole legal thing out of the picture and make the parents, or help the parents, just to become more real and human, and real to each other. So okay, so that's my presentation, and we have, I'm sorry, a little bit less than half an hour. I think it's now about 22 minutes or so left for questions and answers.
Thank you very much, Lynette and Linky. I'd like to open the floor to the colleagues for any questions or comments to our two presenters. Go ahead, Jan.
So let me just keep my mic on. Thank you. Linky and Lynette, firstly, if you compliment you on an excellent presentation, if I can perhaps just make a couple of observations. I've recently found myself in a situation that although I share your view that it's not confidential, the whole process. There can be circumstances where confidentiality is actually necessary. And I've recently actually found such a matter where I've already referred the children to for a forensic investigation in respect of sexual abuse, etc., etc. The father then communicated more information to me that I didn't share with the mother, because my concern was that she will confront the children about that information and contaminate that process. So I've since then changed my terms of reference to specifically allow for that kind of circumstance. So it just shows you there's always something that sometimes just crops up.
Johan, sorry, just to say quickly on that, what I'd like to say there is that I agree with you 100%. There can never be a complete blanket approach to everything. And ultimately, surely the interests of the child, the best interests of the child, will take precedence over everything else.
And then also in respect of the point that the court should, even if the parties don't want to appoint a parenting coordinator, I think that is a very, very valid remark. And often if you can still decide early enough, there's still an opportunity to build the relationships between parties. But once they are set in fight mode and it have been a protracted situation over many years, it is simply wrong. The concern is that I think often legal representatives are not properly trained to realize what the needs are, and to understand that this aspect, and the courts I think also needs to be alive to this, because this does not only pertain to the contact arrangement in terms of Section 7, but how the parties care for the children in terms of Section 9. And this appointment, I believe, if you argue in terms of Section 9 of the Children's Act regarding how they care for a child, there is definitely an excellent opportunity for a court in a child's best interest to order it. And I share what Net have also said, that purely based on the child's best interest, I think these things can be motivated and should be motivated more often. Then also, and Licky and Net, if I can perhaps just request you in your reply, just to perhaps give a bit of background what the directive looks like, how it is structured, etc. It is not just a one or a two line that I've decided. That parties understand. And I think that for those that are not in this sphere, that I think might be helpful if you perhaps just want to comment on that quickly. And then also the importance of how you draft and structure your directive is very important, especially with the possibility of a review. My personal view is that if there is a review coming, and your directive isn't properly structured to provide sufficient information, it forces the court automatically in a situation that it will adopt a wide approach in respect of the review and basically hear the matter they know about. Where if it is properly structured and well formulated, then a classical evidence test should apply to it under those circumstances. And in many instances can, that actually promotes Section 6(4)(b) of the Children's Act that says that decisions must be made quickly. And if you draft it properly, and a court can deal in terms of classical evidence with it and immediately deal with the matter instead of going a protracted hearing or with a couple of postponements, that can certainly save time. And then what Linky and Lynette both said, and I cannot emphasize that enough myself, child participation, critical. And I share your view, Lynette, that you also said independent person, very important. And legal professionals like myself should stay away. It's not our domain. We do not have sufficient skills and training, and there's too much risk that we can miss cues. And we've got no business in that space. Thank you very much. It's been brilliant. Thank you.
Linky, I don't know if you want to answer.
No, I don't think. Yeah.
So I just want to say,
yeah.
Okay. So I just want to say, in terms of how let's say how I draft directives, and I'm not saying that this is the best way or the only way. This is a field that is so new and is definitely growing, and so I'm really open to new ideas. But the way I basically do it is that when I start a PC case, so when I get the court order and I see the people, I'll have my initial consultations with them. There's invariably issues that have to be resolved straight up. And I will write a report. So I have a file and I number my reports. So my very first one is parenting coordinators report number 1 and their names or whatever. And that's usually a long one where I set out how come I am the PC. So where I quote the parts of the court order that kind of put a PC in place. I actually quote not all, sometimes it's far too much, but relevant places of the court order in terms of what I'm empowered to do. My thinking being that when I hand over to somebody else, when I'm replaced, or anybody, or if this goes to court and the judge needs to look at this, he's got a full set, and it sort of sets it out sort of step by step. Okay, so there. Okay, so I start off that first report. That's the only time I ever do that. I will then say that, for example, Mr. van der Merwe raised the following issue, and then I'll say what his concern was. The next thing is I then say that Mrs. van der Merwe's opinion or whatever was this, and this. So here we've got now the different parents' opinions, okay? There might be other information that needs to come after that. For example, like as I said with the school issue, if the children's opinions have their views are relevant for this and they've been obtained, I'll put their views in there too. And then I will have a very short summary in terms of considering this, and this. It appears that this and this would be, kind of pertinent to this issue, whatever. So anybody reading that can get everybody's views and then start to get it for the following directive is issued, and then I list the directive or all the aspects to the directive. So that will happen in one kind of a report. So there might be 3 or 4 directives issued in that report. Then the parents go. The next time there's an issue, they come back again and we deal with that. And that's report number 2. And where relevant, I might refer back to the court order saying, the court order states the following. Okay, and it may be therefore that I can't issue a directive on it. And then I will say, I'm not empowered to issue a directive. I may recommend that they, for example, go and get the child assessed by an educational psychologist or whatever it is, or take the child to a pediatrician or something like that. But if I'm not empowered to issue a directive, I will state there that I'm not empowered to. So I really try to make it very, very user-friendly. I don't know, Johan, whether that helps you in terms of how to set them out.
Yes, thank you. I see your view in respect of that, and that's all. I will also deal with the stuff that we jointly do. I just thought that this is very helpful for people that are not in that working space to understand that it's just a little, here is the decision. There's a process to explain
you
how
cannot,
you do that.
You're spot on. You cannot just send out an email saying, right, the following directive, and it comes out of the blue with no explanation. No, I think that's unprofessional, in my opinion.
Yeah.
Okay.
But I think our time's up. It's quarter to for the next speaker. So
I'm sorry.
Yeah.
Yes.
So
okay.
I won't say anything else.